Hello, everyone. Welcome to Court with Krissy. Let's end our Sunday Funday chatting and catching up on some court clips from the past few days. I hope you like it. Court with Krissy is now in session.
Mr. McClintock, today's hearing is being recorded. Anything you say can be used against you in the future. You have a right to an attorney. If you cannot afford one, you can make an application for a court-appointed attorney. I have complaints here charging you with public indecency and trespass. Did you receive a copy of those?
Yes.
Do you need me to read those to you today?
No, you don't.
Excuse me?
I don't think so.
Okay. Maximum penalty for public indecency is 180 days in jail and a $1,000 fine. Maximum penalty for trespass is 30 days in jail, $250 fine. Do you have any question about those charges?
No.
Okay. How would you like to plead today?
I'd like to plead not guilty if I can get a no or a bond.
How would you like to plead?
Not guilty if I can get a no or a bond today.
Well, I'm not negotiating with you. How would you want to plead today?
I'm not for sure.
Okay. You want to speak to an attorney?
I'd like to.
Okay. You want to say anything before I set your bond?
Huh?
Would you like to say anything before I set your bond?
I just, I hope it's small enough to where I can get it together,
Okay.
I'm kind of in between checks right now, so, I don't have a whole lot of money around to.
Okay. I'll set your bond at $15,000, cash surety 10%, no contact with Alyssa DeCare, who's the alleged victim in this matter, and no return to Hornsville Park. You understand that?
Right.
Okay, thank you.
What I'm going to need to pay?
It's 15,000, 10%. Okay.
What would that be?
That'll be $1,500 cash.
15 cash. I don't know if I want to play that way, not guilty.
Okay. How would you like to plead?
I'd like to just plead guilty. There's no sense in wasting on, that I don't have, or, bondsman.
Okay. You have to tell me what you want to do today.
I'll plead guilty.
Okay. You understand that a guilty plea is a complete admission of your guilt?
Yes.
Okay. You understand you're waiving your right to an attorney?
Can I plead no contest?
Yes. You want to plead no contest?
Yes.
Okay. You understand that the facts in the complaint are sufficient to convict you of the offense I'd find you guilty?
Yes.
Okay. You understand you're waiving your right to an attorney?
Yes.
You understand you're waiving your right to a trial, either to a jury or to the court?
Yeah, yes. I just want to get this over with, for as less as I can.
Okay.
My money's tight right now.
At a trial, you'd have the right to call witnesses to testify on your behalf, subpoena witnesses to force them to appear here and testify, and present evidence in your own behalf. You understand you're giving up those rights?
Yes.
Okay. You also understand you're giving up the right to question any witnesses the state would have against you.
Yes.
And finally, you understand you're giving up the right to have the state prove beyond a reasonable doubt you did in fact commit these offenses.
Yes.
Okay. Okay. The police report states you were trespassed from Hornsville Park, and August 21st you were there, and masturbated in the parking lot. You agree with those facts? Okay. Based on that, I'll accept your no contest plea. I'll find you guilty of public indecency and trespass. I'm going to set a sentencing hearing. Same bond terms that I just went over with you, okay? You understand?
Yes.
All right, thank you. That's all. Hey, Mark, bring that back. That's all. Thank you. Next matter is 24 CRB 1162, State of Ohio versus J. Justice. Mr. Justice, today's hearing is being recorded. Anything you say can be used against you in the future. You have a right to an attorney. If you cannot afford to make an application for court-appointed attorney. I have complaints charging you with obstructing official business and resisting arrest. Did you receive a copy of those?
Yes.
Okay. Do you need me to read those to you today?
No, sir.
Okay. Maximum penalty is 90 days in jail, $750 fine. Do you have any question about the charges?
No, sir.
How would you like to plead today?
No contest, please.
Okay. You understand that the facts in the complaint are sufficient to convict you of those offenses? I'd find you guilty.
Yes.
You understand you're waiving your right to an attorney?
Yes.
You understand you're waiving your right to a trial, either to a jury or to the court?
Yes, I do.
Okay. At a trial, you'd be able to call witnesses to testify on your behalf, subpoena witnesses to force them to appear here and testify, and present evidence in your own behalf. You understand you're giving up those rights?
Yes, sir.
You understand you're giving up the right to question any witnesses the state would have against you?
Yes, sir.
And finally, you understand you're giving up the right to have the state prove beyond a reasonable doubt you did in fact commit these offenses?
Yes, sir.
Okay. Okay, police report states that on August 21st, you did not respond to police officers' verbal commands. You fled.
I didn't flee anything.
Had to be tased.
Yeah.
Okay.
Yeah, I walked away from him peacefully because he had no reason to stop me to begin with.
Okay. All right. You want to plead no contest?
Yeah.
Okay. Based on those facts, I'll accept your no contest plea. Find you guilty of obstruction and resisting. I must have a sentencing hearing. You want to say anything before I set your bond?
No.
Yeah.
A sentencing hearing.
Yeah. We'll decide what your sentence will be at the sentencing hearing. Okay?
Yeah, I plead no contest. I don't have any money for a bond. Am I going to release my own recognizances at least?
No, I'm gonna set your bond, and we'll have a sentencing hearing based on your no contest plea. Did you want to plead not guilty?
Yeah, I mean, I didn't think I'd receive any jail time for this anyway. There wasn't even charges that made sense on this, so.
Well, you need to tell me what you want to do.
All right, I'll plead not guilty then.
Okay. Okay, if you need a court-appointed attorney, get the paperwork filled out. I'll set your bond at $2,500, cash surety 10%. Thank you.
Are you shitting me? Are you shitting me?
Is this person going on? Terry Reed.
Stephen Barnes from Dearborn. Have you interviewed them yet?
Nobody yet. I only have Mr. Harris. I'm going to hang up and start Dearborn and then work my way up.
Work your way up?
Unless
work
you
your
want
way
to
down?
actually. No, up, because technically Dearborn's the 19th District Court, and then we got the 20th District Court, then we got the 34th District Court.
Okay. So how do you want me to proceed?
I want you to give everybody a personal bond.
I didn't ask that. That goes without saying. You're doing your Captain Obvious routine again. Do you want me to log in? No, you want me to log in and put you all in a breakout room? That's really my question.
Yeah, let's do it. Let's do it that way.
Okay. All right. I know you want a personal bond.
Just making sure.
That goes without saying. No. I mean, you got a standing personal bond recommendation. I know how you roll.
Thank you, Your Honor.
Very, very rare. The only time you ask for a cash bond is when a remand is a consideration. That's when you begging for the cash bond.
I'll do whatever I gotta do to get for my clients, Judge. Bagging, fighting, dancing.
You do a great job of advocating for your clients. I do give you that. I have a great deal of respect for you. You do advocate zealously for your clients, and I respect that.
Thank you.
Tate. What's your name?
Sean James Tate.
Case number 240-593-9601. Please submit Mr. Sean Tate. Appearance, please.
Ryan Murad, PA 3665. On behalf of Mr. Sean Tate, we waive the reading. Mr. Tate stands mute. He's been advised of his rights.
We're in a not guilty plea on behalf of Mr. Tate. Given the charges like a criminal history, we'll give Mr. Tate a $5,000 personal bond while his case is pending. Sir, you're not to possess any handguns, firearms, or other dangerous weapons. Probable cause September 23rd for the Judge Kevin Robbins. Preliminary examination September 30th for the Judge Jefferson. Have a good day. Step aside, please.
Thank you.
I hear what you said, sir.
Personal bond. Have a good day.
Oh, my bad. I apologize. Thank you. Please, thank you.
Good morning, Marian, Commissioner Harper. Good afternoon.
Case number 240-593-9301. Please submit Mr. Marian Harper. Appearances, please.
Ryan Murad, PA 3665. On behalf of Mr. Harper, Your Honor, we waive the formal reading. Mr. Harper stands mute. He's been advised of his constitutional rights.
We're not guilty plea on behalf of your client. What is your bond? Why should I not give him a cash bond, Mr. Murad?
Your Honor, it's my understanding this is a matter where Internal Affairs actually took pictures regarding Mr. Harper's injury suffered at the hands of the Detroit Police Department. I can tell you that he has nothing on his record besides a non-assaultive case that was successfully resolved under HIDA. He's gainfully employed at a factory. He works 5 p.m. to 5 a.m. I think that this is a charge of resisting and obstructing with no underlying charge. For all those reasons, Your Honor, I'm asking the court for personal bond. I don't want to have to get too far into it, but I can give you more if you'd like.
No. All right, $10,000 personal bond. Probable cause September 23rd. Preliminary examination September 30th. Have a good day, sir.
Thank you, Your Honor.
Thank you. Have a blessing, sir.
Judge, I'm sorry, Judge of Record.
Giles.
Thank you, Your Honor.
I signed one, didn't I? What's your name?
Juan.
This is case number 240-594-0001. People City, Michigan versus Juan Collins. Appearances, please.
Ryan Murad, PA 3665. On behalf of Mr. Juan Collins, we waive the reading. Mr. Collins stands mute. He's been advised of his rights.
Forward of not guilty plea on behalf of Mr. Collins. I read the investigator's report on this, and the allegations are, even though these are a serious assault of nature, when I looked at the age of the complaining witness, he stole a bike from a 10-year-old kid. Those are the allegations. Pushed the kid off the bike to take his bike. Now, it's not very, very serious assaultive, but my gosh. Is your client employed, Mr. Murad?
He is, Judge. He's full-time. The bike actually belonged to Mr. Collins' daughter, but he is gainfully employed. Yes, full-time.
All right. I'm going to give him a $5,000 personal bond. Probable cause September 23rd, preliminary examination September 30th, both in front of Judge Jefferson. Have a good day, sir. Step aside.
Thank you, Ron.
What's your name, sir?
Tony Cash.
Case number 240-594-0201. People submission versus Tony Cash. Appearances, please.
Ryan Murad, PA 3665. On behalf of Mr. Tony Cash, we waive the reading. Mr. Cash stands mute. He's been advised of his rights.
Forward of not guilty plea on behalf of Mr. Cash. Mr. Rob, why should I give Mr. Cash a cash bond?
Your Honor, he doesn't have any prior criminal history. He has a stable residence with his mother, and he's gainfully employed at both Planet Fitness and Taco Bell, and he's in school, and he's in the Navy. He's done 5 years in the Navy. I think he's a great candidate for
In
a
the
personal
Navy. Like the YMCA song, In the Navy. Okay. He works at Taco Bell and does what?
And Planet Fitness, and he's in school.
Where is he in school? Where's your time for school?
Mr. Cash?
Letting right now, sir.
You what?
Letting. It's for letting. It's a program for in ECW.
Looks like it's a trade school.
Yeah, Detroit trade school, basically.
All right. Is it online or in person?
It's in person, sir.
You got a lot going on there. All right, $10,000 personal bond. Probable cause September 24th, preliminary examination October 1st, both in front of Judge Taylor. Step aside, have a good day.
Yes, sir. Thank you, Your Honor.
Thank you, Ron.
What's your name?
Jaylen Sanders.
Case number 240-450-8401. Here's to the Michigan versus Jaylen Sanders. Appearances, please.
Ryan Murad, PA 3665. On behalf of Mr. Jaylen Sanders, we waive the formal reading. Mr. Sanders stands mute. He's been advised of his rights.
Forward or not guilty plea on behalf of Mr. Sanders. Mr. Murad, does your client have an alternative place to stay while this case is pending?
Yes, Your Honor. He indicates that he's going to be residing on Stout Street, not on Coyle Street, while the matter is pending.
Where?
On Stout Street with his girlfriend.
Okay, make your argument as the bond.
Judge, Mr. Sanders is 22 years old. He indicates he doesn't have a prior criminal history, that there aren't any matters pending against him at this time, that he does not reside with the complaining witness at this time, that he resides with his girlfriend on Stout Street. The complaining witness appears to be his mother. I read the report. It doesn't appear that there were any injuries or anything along those lines. I think it was just maybe a tense situation that may have been escalated with police presence. I'd ask the court ultimately for personal bond, no contact with residents or complainant.
Is he employed or in school?
No, Your Honor.
He's not?
No, Judge. He does also take some medication that he indicates he's not received.
$10,000 personal bond. GPS tether, 9 p.m. to 6 a.m. curfew. You're not possessing any handguns, firearms, other dangerous weapons, no contact with your mother, and you cannot go back to the call address. Is that clear, sir?
So I gotta pay for the tether?
You what?
I gotta pay for the tether?
So not at this time, sir. Eventually, you may have to pay for the tether on the back end, but at this time, you don't have to pay for the tether to be released.
So I gotta go to Wayne County?
Until they have a tether for you.
Hey, bro, keep
And I
asking.
want to put.
Your Honor, would you reconsider the tether provision given Mr. Sanders' lack of?
I was just about to articulate the reason why I'm giving the. The reason why I'm giving the tether. The report indicates from the mother, when the mother was interviewed, that there was an assault reported on September 4th, 9 days earlier. And so I don't know where that assault occurred. I assume possibly it was at the call address, but the situation seems to be escalating. And I want to track him, make sure he's tracked, and make sure he doesn't go back to the call address. And so that's the reason for the tether, Mr. Rod. Pre-trial, October 2nd, in front of Judge Garrett. Have a good day.
So I can speak to him. I can speak to you with the green shirt.
Sorry, Your Honor. Sorry, sir.
I can speak to you.
Not on this, sir. We're live in court. We would have to go into a breakout room. Your Honor, can we be placed in a breakout room?
For a couple of minutes. I'm not going to put you in there for long.
Thank you, Your Honor.
All right. Can I speak to the gentleman in the green shirt?
He's here, Your Honor.
Stay full now.
Reno, Diandre, then.
Did you say your first name is Reno?
Yes, ma'am.
All right. Reno, Diandre, Dandy. Mr. Dandy, this is Magistrate Chartea. You hear a criminal matter. Case number is 240-592-1701, sir. You do have an attorney.
Jessica Scheib, on behalf of Mr. Dandy, who waives formal reading, understands his constitutional rights, and stands mute.
I'm going to enter a plea of not guilty. Court dates are September 13, 2024. It is a probable cause conference, followed by preliminary examination, September 20th, 2024. Both matters are going to be in front of Judge Taylor. Mr. Dandy, okay. Let's see. First of all, bond conditions. You're not to possess any firearms or any other dangerous weapons. You're not to have contact with a Dominique Harris. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Do you understand those bond conditions, sir?
Yes, Your Honor.
Okay. That being said, Counsel Coyle, you're here on behalf of the people.
Yes, Lisa Coyle appearing on behalf of the people. Your Honor, the people in this matter are asking for a $25,000 cash surety bond, tether house arrest. And I understand that this just occurred on the 1st. He is charged with the life offense. The only thing I see on Mr. Dandy's CCH is a 2017 CCW case, but the charges here are extremely serious in the fact that I'm not saying that he's a danger necessarily to the complainant in this matter. It appears that they were strangers, but he is a danger to the community. There were witnesses at this restaurant that said he appeared to be on drugs and or intoxicated at the time. He had made verbal threats to the complainant in this matter, Mr. Harris, and others while at that restaurant. He said, you all better be careful. I'll kill you, and then threw a punch at the victim. The victim then punched back, and then the defendant pulled out a pocket knife, I believe, and began stabbing at the complainant. The complainant was stabbed 4 times, twice in the shoulder, once in the hip, and once in the thigh. Multiple other witnesses are there that would be able to testify and corroborate what occurred with the complainant in this matter. He is a danger to the community, and for that reason, Your Honor, based on the allegations set forth with, I'm asking for that $25,000 cash surety tether house arrest.
Okay. Well, that being said, Counsel Scheibe, I'll let you go in a minute, but Mr. Harris, there's no alcohol or illegal controlled substances. You can't possess them. You can't use them. Do you understand that, sir?
Yes, sir. Yes, Your Honor.
Thank you. All right. Counsel Scheibe?
Your Honor, first off, I'd like the court to look at my client and his 2 black eyes on his face that, now is 4 days later of this alleged incident, and still he looks like this. So, I can only imagine what he looked like 3 days later, which wouldn't make sense with the report, because allegedly the victim says that a witness says that the victim punched him only 1 time. But given how the court could see both of his eyes, Your Honor, and given that in the report, it says that when the officers arrived, they observed the defendant lying on the floor, unconscious and covered in blood, Your Honor. And I don't know how that would happen from allegedly just 1 punch from a victim. And even if there was just 1 punch, the victim here should also be charged for assault, Your Honor. The other thing is that when they tried to talk to a witness, it says on September 2nd, under investigation on the 2nd page, it says witness 1 stated he was upstairs, so he did not witness the incident. But he did see the defendant lying unconscious on the floor. And Your Honor, so then, witness 2 says that they saw the complaining witness punch the defendant after allegedly the defendant, my client, made a threat. However, his injuries do not, again, make sense with what's in the report, because if my client was the victim here and this is what he looked like, we know what the court would do, Your Honor. Also, it says that when they went to speak to the complaining witness himself at the hospital, he couldn't identify or describe the defendant, Your Honor. So we have that issue there too. So respectful, and it also says that on September 2nd, they called the victim and that who wasn't available. And the complaining witness was not at the address that they listed, called him again. But it says the person who answered the phone identified themselves as the victim and confirmed they had been stabbed, but that they did not want to press charges. And after they asked if he would be willing to sign a form stating he does not wish to move forward with the case, and he said no and hung up. So we have a victim, a complaining witness, who's not cooperating with the police, it appears, to this report. And we have a defendant who's in front of you who looks like the victim to me, Your Honor, 3 days later after the injuries. So, and was unconscious on the floor. So we weren't there. I don't know what was going on there, Your Honor. He will have his day in court. He was arrested at the hospital. He is employed, Your Honor. He's a lifelong resident of Michigan. We're not aware of anything assaultive on his record whatsoever. He has a 2017 carrying a concealed weapon charge, which is non-assaultive, Your Honor. Other than that, we're not aware of anything. We don't believe he's at flight risk or a danger. So respectfully asking the court to consider a personal bond here, Your Honor. And I know that on charges like this, the court usually doesn't do that. But I think if the court looks at my client and looks at the report, that may change things for him for bond, Your Honor.
Your Honor,
Thank
if I
you.
may briefly say, my guess is what happened after the victim got stabbed, because he was verbally assaulted and then he was physically assaulted. He has the right to punch back. And that he then gets stabbed. My guess is there was a beatdown by the other people in the restaurant on the defendant. And that's why he's laying unconscious, because the victim's already gone. He went to the hospital.
Okay.
So my guess is that's what happened. Okay. Using our common sense about what happened, because nobody said that the victim was, he has 2 black eyes. So he's self-identifying as the person that was at the restaurant.
Thank you.
Okay.
Thank you, folks. Okay. In this particular matter, Counsel Coyle, what was your recommendation?
I asked for a $25,000 cash surety tether house arrest.
Okay. And I know Counsel Scheib wanted a personal bond. Is that correct, Counsel Scheib?
Yes, Your Honor.
Okay. Court has heard the representations. Court starts off with a personal bond status in this particular murder. Court has looked at the allegations. Court has heard the representations, and both sides know that in this matter, even if the complainant or the victim says they do not wish to proceed or prosecute, press charges, it is not up to the victim. It is up to the prosecutor's office if they wish to proceed. With all that being said, this court does, using clear and convincing evidence standard, that Mr. Dandy, he is a danger. Okay, we are going to follow the recommendation of $25,000 cash surety. We're also going to put him on a GPS tether, house arrest. If he gets out on bond, I'm going to make this, but that also means Mr. Dandy, this Friday, 9 o'clock, you're going to go in front of Judge either Mechanico or Judge Williams, who's going to be looking at the bond amount and bond conditions. Do you understand that, Mr. Dandy?
You said it won't be the 13th, it'll be Friday?
No. But just dealing with the bond and bond conditions, okay, that will be this Friday. Let's just say that you don't make bond. Nobody posts bond, okay, you will get a court date this Friday, Judge Mechanical or Judge Williams, who will look at the bond amount and bond conditions. If they change, then you'll know on Friday. Thank you, sir. That concludes your arraignment.
All right, very good. We're only now 23 minutes behind. Do you want to just keep rolling, Mr. Mersinski?
Yes, Your Honor.
All right, we'll try to get through this. State versus Mindy Borges, 24 CR 195. Austin Fallsgraff's appearing from the courtroom. Mrs. Borges at the jail there. Mr. Fallsgraff.
Yes, Judge, I didn't know Miss Borges was at the jail. Given the severity of the offenses, I'm going to be making an impromptu OR bond motion.
Okay, go ahead.
All right, Judge, simply, without knowing anything more on the case, we have a paraphernalia and a seatbelt violation. Even if
there was a failure to appear. There was a
summons issue.
Okay. Given under the circumstances, and I think after Miss Borges has been in custody for this long over these offenses, or at least she's been in custody for a little bit, I would anticipate that she would gladly be at whatever court date is set hereafter. I would just request an OR bond based on those facts.
If I recall correctly, I tried to talk her into that, but she was of the opinion that she just couldn't get to court and her shoulder hurt. No. So I didn't really know where to go with that. It just didn't seem like she was going to show. Does that make any sense?
Yeah, Judge, it's your call. If this court was to not grant an OR bond, it would be my request that this just be a 1 week continuance, and I think we will have a resolution.
Well, let's ask Miss Borges now. You lived on A Street? Am I remembering the right person?
Yes, Your Honor.
All right. And you got served your summons, as I recall, and then
Yeah.
you weren't gonna walk a couple blocks to court because your shoulder hurt and you had no ride, and that had nothing had changed, and that was it. That was the case.
No, I called the court and they told me to use Zoom court and I couldn't figure the Zoom court out.
Right, but then you couldn't figure Zoom court out, but you wouldn't come to court either. And I don't really want to put you back out. You can't figure out Zoom court, but you're not going to walk to court.
No, I didn't, no, I will be to court. I promise I will go to court.
Is your shoulder good enough to walk to court now?
Yes, yes. I
Right.
promise. I promise.
'Cause I don't want to hold you in jail, but you just act like well, Zoom didn't work. My shoulder hurts. I'm not coming to court. That's what it seemed like to me.
I have schizophrenia.
Huh? Just schizophrenia. Okay.
No, I will be to court. I promise. That's not how I was trying to act. And that's
There's a
not.
lot of issues here. All right. State's position on bond.
I don't take any position, Judge, whatever you want to do.
I mean, it's we got lots of issues here, but I guess we'll just see. Are you on your medication?
No,
You're not on medication now?
on hydroxychloroquine. They have me on some right now, yes.
Okay, and you have medication when you're out?
No, I wasn't on it when I was out.
Well, do you have some when if I release you, do you have any?
Yes. Yes, sir.
Okay. We'll try you got to come to court, okay?
I promise.
$1,000 own recognizance bond. Let's see here. When do you want this set, Mr. Falsgraf?
26, if that's amenable to the court.
All right, September 26th at 2:30. All right. You need to stay in contact with your attorney. Do you have his contact information?
Yes, I do.
All right. Stay in contact with him. Be back in court, okay?
Okay,
September 26th at 2:30. Write that down.
I will.
All right.
Thank you.
All right. State versus Terrell Brumley.
May I have your name, please?
Christopher Frisbee.
All right, Mr. Frisbee, you've been charged with 2 misdemeanors, criminal trespass, that bond is 1,000, and public drunkenness, that bond is 500. Your total bond amount is $1,500. While this bond condition is in place, you can't go back to the Chevron at 222 Upper Riverdale Road in Jonesboro, Georgia. You understand everything I've said so far?
Yes.
Okay. If you don't make your $1,500 bond before October 15th, on October 15th, there will be a hearing by video conference to determine if there's enough evidence to keep you in jail on the charges that I just mentioned to you. That's your preliminary hearing. But if you make bond before then, you won't have that hearing because you're no longer in jail. You've waived it by bonding out. You can also sign a waiver today, waive it ahead of time if you choose to do so. You want to sign a waiver to waive it ahead of time, or do you want to leave it scheduled and let it bond out? And let it waive on its own.
I wanted to ask a question. They said if I don't bond, they will release me in 48 hours.
I'm not sure who they is, but
I only had the drunk thing because I was using the restroom. I was trespassing the store. I was using the restroom.
So the criminal trespass, if you want me to read the warrant to you so you can understand how you got the charge, I can. Is indicating that you caused some damage at the Chevron. Do you want me to read the warrant for you?
Yes.
Okay, so it indicates that on September 13th, 2024, that you committed the offense of criminal trespass when you provoked a customer at the Chevron at 222 Upper Riverdale Road in Jonesboro, Georgia, with a bottle of alcohol in your hand, resulting in a physical altercation that knocked over multiple shelves, goods, and merchandise all over the floor, damaging some. Damages were less than $500. That offender was in a public place, visibly intoxicated, walking with staggered steps, and emitting a strong odor of alcoholic beverage. And this incident occurred in Clayton County. That's how you got the criminal trespass charges, because you damaged property that didn't belong to you, allegedly. So I'm not sure what you're referring to, but you're here before me. I am the judge giving you your charges and your bond. And I've stated that your bond is $1,500. I'm going to leave your court date scheduled for October 15th. If you make bond before then, you won't have court on that date. You'll receive a new court date by mail. Remember, you cannot go back to that Chevron gas station. Give me one moment. I will give you everything you need to know. And then before you leave, I promise I'll ask you if you have any questions, okay? So remember, you cannot go back to the Chevron gas station in Jonesboro, Georgia on Upper Riverdale Road. Now, I did receive your application for a public defender, but it was not filled out. Do you want to be considered for a public defender, or do you plan to hire your own attorney or represent yourself?
If I bond out, I still got to go there.
Where's there? What are you referring to?
Court date, October 15th.
No, remember, if you make bond before October 15th, you won't have that hearing. That hearing is only if you're still in jail.
Okay, so I'm gonna have that hearing if I'm still in jail, is what you're telling me.
Correct. If you don't make your $1,500 bond by October 15th, then on October 15th, there will be a preliminary hearing to determine if there's enough evidence to keep you in jail.
So the bond is 1,500, or is it less than that?
Your bond is $1,500. You will pay $1,500 cash to the sheriff's office. If you don't have it, you can call around to some bonding companies and they will charge you a certain percentage of the $1,500 for you to make bond. So you'll have to contact the bonding company and ask them how much. Now, I asked you a question that you have yet to answer. What are your plans for hiring an attorney? Do you want to be considered for a public defender, or do you plan to hire your own attorney or represent yourself?
Public defender.
Okay. Do you have a job, Mr. Frisbee?
Not currently, no. I was doing landscaping, but that was under the table.
Do you have any source of income?
Yes, but right now we're not working at the moment.
All right, I'm going to appoint an attorney to represent you. And you'll be able to, if you have any further questions, you'll be able to talk to your attorney. I can't give you legal advice, but if you have questions about the information I gave you regarding your bond, your charges, and your court date, I'll go ahead and hear you now. What questions do you have?
Can somebody go to my mother's house to inform her that I'm in jail? Negative. Negative? All right.
You'll have to make a phone call, sir. So the only thing I can explain to you is your bond amount and then your charges and your court date. As far as how you bond out, that's something that you have to figure out, okay? Just whenever you make a phone call, just make sure they're aware that your bond is $1,500. Make sure you sign on the system before you leave and you're free to go.
That way. Thank you.
You're welcome.
Next person on.
May I have your name, please?
Yeah.
You said Deon Price?
Yes, ma'am.
Okay. All right, Mr. Price, you have, all right, so you have been charged with felonies and misdemeanors. So your felony charges are theft by receiving stolen property, fleeing or attempting to elude a police officer, falsification of an identification number, and I have not granted bond on those. I'm scheduling a separate bond hearing date for you. In reviewing your criminal history, I see you have some pending felony charges as of July 2024 out of East Point Police Department for some similar offenses. I'm not granting bond on your felony charges. Your bond hearing date will be October 18th at 8:30 in the morning by video conference. At that time, a different judge will conduct a hearing. The state will be present, your lawyer and you will be present, and any witnesses will be present. And then the court will determine your bond at that time. You do have misdemeanor charges, and those are reckless driving. Now, I did set bond on your misdemeanors, but because you didn't get bond on the felonies, you won't be able to bond out. But let me still tell you what the bond is on your misdemeanors. So your reckless driving, that bond is $2,000. Obstruction of an officer, the misdemeanor type, that bond is $2,000. Driving while license suspended, that bond is $1,000. And affixing of a plate to conceal or misrepresent the identity of a vehicle, that bond is $1,000. So again, your bond hearing date will take place on October 18th, 2024 at 8:30. You're also going to have a preliminary hearing that will take place on October 16th. So a couple of days beforehand, on October 16th, there will be a hearing to determine if there's enough evidence to keep you in jail on the charges that I just mentioned to you. Let me take a look at your application for a public defender. Based on your responses, I am appointing a public defender to represent you. Do you understand everything I've stated so far?
Yes, ma'am.
Okay, do you have any questions about what I've said to you so far?
Yes, ma'am.
Okay, what's your question?
May you explain the one charge you like failure to vehicle appearance, something like that?
Oh, hold on, let me see. Falsification of identification number?
Yes, ma'am. What is that?
Okay, hold on, let me pull up your warrant here. Okay, so I'll tell you what the warrant says, Mr. Price. It says that on yesterday, September 13th, there was a be on the lookout for a stolen white Dodge Challenger that was traveling toward the city of Riverdale on Highway 85. The Dodge Challenger had an LA tag of 973 GJI, and hold on. That tag was affixed to the rear of the Challenger with the intent of misrepresenting the identity of the vehicle. The tag belonged to a different stolen vehicle. And then an officer from the city of Riverdale located the vehicle on Highway 85 and asked the sheriff's office for assistance. When the defendant noticed that he was being followed, he began to flee. The deputies who arrived in the area began to pursue the vehicle until losing sight of it on Highway 314 and Bethsaida Road. The officer received a law enforcement notification that the vehicle was traveling west on Flat Shoals Road toward Old National Highway. Knowing the area, the officer intercepted the vehicle at Old National Highway and Godby Road. The officer initiated a second pursuit stemming from the original charges. The defendant fled at speeds over 20 miles per hour above the posted speed limits. In some cases, the speed was over 120 miles per hour on surface streets. The defendant ran several red lights, stop signs with an absolute disregard for the safety of other drivers. Once the pursuit reached Lee Street, just north of Campbellton Road in the city of Atlanta, I conducted a maneuver, causing the suspect to stop the Challenger and flee on foot. He was captured while trying to climb a fence and only gave up when I tased him. After identifying him by name and date of birth, I found his license was suspended for failure to appear since May 19th of 2022. Upon inspecting the Challenger he fled in, I discovered the VIN in the window was a fake VIN number. The door sticker was also a fake VIN number. I located the true VIN number, and a GCIC inquiry showed the Challenger had been stolen since July 26th of 2024. So that is why you got the charge there about falsification of an identification number because of the allegations about the incorrect VIN numbers on the vehicle. All right. So as I mentioned, your bond hearing will be October 18th. Your preliminary hearing is October 16th. And I appointed an attorney to represent you. Do you have any other questions?
So can I pay this bond that I have now?
You won't be able to bond out on your felony charges. So even if you paid the misdemeanor bonds, you still won't be released.
Yes, ma'am. But
Okay.
can I pay it? Yes.
You'll have to ask the jail. I mean, you'll have to, if you do believe you have the bond money for the misdemeanor, you can ask the jail, but you won't be released. So I doubt that gets you anywhere. But if you want to go ahead and start getting your money together, that will probably be best. So then on October 18th, when you appear before another judge, whatever bond amount they tell you, if you are given a bond, then you would need to take that into consideration too. Okay. All right. So that's all I have for you, Mr. Price. Just make sure you sign on the system before you leave.